Good evening, everybody, and welcome to Celebrating and Supporting Internationally Educated Nursing Staff session this evening. My name is Lucy Michina. I'm the Regional Director for the Southwest, and we are pleased to be hosting the session today. So it's really good to have you here. Today's session is targeting the internationally educated nursing staff from the independent sector. So you're very warmly welcomed here, and I hope you find the session useful. We will be sharing about employment and contract terms and conditions, and you will also be hearing from our legal team who will be sharing about repayment clauses, amongst other things, including the immigration skill charge. Just to mention that you can use the session this evening for your revalidation. Colleagues will be introducing themselves as they come in to present on their topic. We also have the chat function, which you can use to post any questions, and we will aim to respond to these as we go through these sessions. So I'm just now going to hand over to Claire Sutton, who will be starting the first session. Thank you.
Thanks very much, Lucy. Hi, everybody. My name's Claire Sutton, and I'm the Transformational Lead for the Independent Health and Social Care sector. And I'm joined by my colleague tonight, Carol. Carol, would you like to introduce yourself before we start our session?
Hi, everyone. I'm Carol Dale, and I am the Independent Health and Social Care Lead for Scotland and work within the UK.
So Carol and I are going to go through some information for you about your contracts of employment and what they mean. So if you can go on to the next slide for me, please. As you can see by this slide, it's not a light topic. It's quite heavy, and there's lots of information in these slides. And you will be able to get copies of these slides afterwards, and all of the information is on our website as well. So firstly, we strongly believe that all of the nursing workforce should be recognised and valued through having their pay terms and conditions. And a contract of employment is a legally binding document. You must, first and foremost, always read any contract fully and make sure you fully understand that before you sign it. And that's really, really important. That's your one takeaway from this. Make sure you read it thoroughly and understand everything you're reading before you sign on that dotted line. So you are protected by law, and you're classed as an employee or worker, and you've got the right to have a written statement of your employment particulars. That written statement includes some of the main terms and conditions of your employment, such as your pay or working hours. And sometimes it's referred to as a contract, but a contract is much broader than just that written statement. So when we say it's broader, it might include lots of other things, including things about what you'll have to do with data governance, so keeping information, sensitive information confidential, your organisation's code of conduct, so how they expect you to behave during your work, and some other policies as well. So some key employment policies might be included in your contract of employment. So if you started your work before the 6th of April 2020, then you don't have the same legal right to a written statement, but you've still got a legal right to a contract of employment. So there are times when your contract can be changed, and it's both binding on yourself as an employee, but also your employer. So you can't just change the contract of employment as an employee or an employer without the agreement of the other. So you'll notice when you get your contract, there's usually two boxes to sign, one for you and one for your employer. So you must both agree with that change. You must have that, you must have it written into your contract that there is the right to make those changes. You can use flexibility clauses to make reasonable changes within your contract. So that doesn't mean that the whole thing can be changed. It's got to be reasonable and acceptable for both yourself and your employer. And you should always check, again, that contract when you first sign it, to check if it does have that flexibility clause, because it can mean that your employer has got that ability to make these. Some of those changes might not feel particularly reasonable, so that's why it's always good to double check it before you sign on there. So, right, you'll notice I'm not reading out all of these points, and that's because we will share them with you, and there's so much information to provide you with. It's quite normal in a contract of employment to have a probationary period as a term of that contract. That starts from day one, and it will last a number of weeks or months, and that can vary. Sometimes it can be 4 weeks, sometimes it can be 6 months. Some employers will offer their employees less favourable terms and conditions, and sometimes even a lower salary during a probationary period. They can do this as long as it's written into that contract that, of course, you will have read and understood, but they can't take away your basic legal rights. So you are treated as an employee from day one. Your continuity of employment, so the period of time that you have been employed by your employer, starts on the first day of your job and not on the day when your probation period ends. So this can become quite important if length of service is used for certain entitlements, such as annual leave. You start to accrue that annual leave from the first day you're employed, not from the day you pass your probationary period. Your probationary period can sometimes be extended. So extension should be a reasonable length and for a specific purpose. So it could be that you've missed a period of your probationary period because you've been off sick, so you've been unable to demonstrate or prove that you meet the requirements that you needed. Your employer must give you a reason why they're extending it. They can't just say, oh, no, we're extending it for another 6 months. They've got to give you a reason why and a process by which you can meet any goals and make sure that you've got that ability to be able to meet that probationary period. Your notice period should always be detailed in your contract of employment. So we do provide quite a bit of information about notice periods on our advice guide. You can sometimes be dismissed during your probation period on a shorter notice than once you're confirmed. So quite often it can be written in that you might have to give a month's notice, but during your probationary period, that may only be a week. And that is that's for yourself to give your employer notice that you intend to leave that role. Sometimes performance issues can be raised during a probationary period, but you must always make sure that any goals that you're set in order to be able to meet them are SMART goals. They need to be specific, measurable, achievable, relevant and time bound. And again, we give more information about that on our website. So there's some really, really important do's and don'ts that you need to do. Never, ever sign a contract that you don't understand. That's really, really important. If you're presented with a contract and you've got questions about it, then you can contact RCN Direct and they can give you information about that. If there are gaps in your contract where there are blank spaces, don't sign it. Ask for those gaps to be filled in. It can be sometimes that you'll sign a contract and it'll have like a start date to be confirmed, but you'll want to know that that's going to be confirmed. Don't place any reliance on verbal promises. A verbal contract isn't a contract. You've not had it in writing, you've not signed it, so it's really, really difficult to prove should you need to. Be really careful about any repayment clauses that can be enforced if you want to leave your job. Sometimes these can be built into contracts, and you will hear more about this later on in tonight's webinar, but just watch out for them and make sure that you're aware of them before you sign that contract. If a contract refers to any documents or policies, ask for copies of those as well, because if it refers to them and it says, you know, as per our contract on annual leave, you'll want to see a copy of that because it forms a part of that contract that you're signing. If you're unsure about anything, ask for written clarification. That's really important. And make sure that if you've got any questions or any objections, anything you don't agree with in that contract, that you pop that in writing as well, so that your employer and yourselves have got a paper trail before you commit to this contract and before you sign it. So I mentioned earlier that your period of working for an organisation begins on the day that you start work. So it's the case, your employment begins when you start work. if you have failed to give if as an employer, sorry, I'm messing my words up here, aren't I? Failed to give your employee that written statement and you don't put any other parts of the contract in writing, it's still classed as being when your employment begins. It could potentially be formed a bit earlier than that if all of the following apply. So if your employer sets out the terms of your job in a clear and definite way, verbally or in writing, the job offer was unconditional, or you meet all of the conditions, for example, if your employer is satisfied with all of the references, and if you accepted a job verbally or in writing. So I'm going to pass over now to Carol, and she's going to give you some more information. Thank you.
Hi there. So we're going to talk about, next slide please. Claire's just gone over when the contract begins. So I'm going to talk to you a wee bit about implied terms. So implied terms are, things that are not necessarily written into that contract, but we would expect to have them, and that's either with the employer having them or you as an employee. So for example, that might be that you don't steal from your employer, and in turn that might be that your employer has a safe working environment for you. So it won't necessarily state that in the contract, but these are implied terms. So they describe them as too obvious to be written, and sometimes people will pick that up. There are some very, very obvious things in that two examples that I gave you there. Statutory, that means that they come from employment law. So there's also implied through custom and practice, so that's sort of known ways of working, how we work. So terms can be implied if they're necessary for the efficacy of the business. This means they're needed to make the working relationship possible. The other thing would be conduct terms. This is when people's behaviour suggests they've agreed something, even though they have not written it down or spoken about it. Some of these things can be quite difficult to prove, but we're talking about kind of as I said before, some of these very quite obvious things as well. So again, just continuing on from that, so your terms in the contract, as we said before, they don't have to be written down. An employment tribunal judge would still, if you had to go to a tribunal, they'll still take that into consideration, and they'll consider the terms that are too obvious, like we've talked about there, to be written, if it passes what they call the official bystander test. So that's when it's so obvious that the employer and employee intended to include a term, they didn't feel they needed to make it an express term. Even if they're unwritten, these terms are often crucial for an effective working relationship between an employer and an employee. So to prevent misunderstandings there, the employer should make clear the standards of behaviour expected from employees. For example, anyone who deals with customers should be polite, and quite often we find that within services there's a code of conduct, and their expectations are written down there as well. There's a lot of information obviously here tonight, but we have excellent website that you'll be able to get more information on this, obviously be able to ask questions, and we also have our CN Direct if you phone up and I want to ask any questions and get anything clarified, because I appreciate it can be a lot to take in. So what happens if these aren't met? For example, the employer will investigate reports of theft and pass them to the police if necessary. So they might not have that written down in their contract, but they can, obviously they would have the police investigate that. And that also takes on board as well notifications to, for example, Nursing and Midwifery Council and other bodies. The employer should also make clear the standards of behaviour that their employees can expect of them. For example, what support they'll put in place to meet their duty of care. This should include an employee assistance programme or mental health first aiders, and we've seen certainly during the pandemic and since that a lot of employers within the independent sector are doing more than this than they did previously. It was very much more an NHS focused thing before. It's certainly now available there, and you've got also to remember as well, you have support that you can access via the Royal College of Nursing, and we offer career support, counselling, etc. as well, and we have our own wellbeing hubs as well. The employer should really put this in writing, for example, in the employee handbook, because you don't know what you don't know, and you would hope that that's part of your choice. Maybe when you're looking for a job, is what is that employer offering you, and that would be, you know, be considered to be a good employer if they're supporting you in this way. So options, what can you do if your employer breaches your contract? So you can respond, there's numerous ways you can respond to that. So I'll just go through them all in turn. You could agree to the breach by carrying on working under the revised terms. You raise a grievance or make a claim to an employment tribunal, industrial tribunals in Northern Ireland. You would need to have made it clear to your employer that you do not accept the new terms and conditions. You could refuse to work under the new terms. Your employer may then decide to dismiss you and to hire you on a new contract with new terms and conditions. And I know that might sound unfair, but that's an option that sometimes people go down that route. If this happens, you may be able to bring a claim for unfair dismissal. It's important to be aware that employment tribunals frequently find dismissals fair if the employer can point to good reasons for introducing the changes to the contract. For example, economic necessity. If this dismissal is without notice, you may be able to bring a claim for wrongful dismissal. Anything like that, I would strongly suggest that you contact RCN for advice on that, and we can certainly keep you right on that. And I would always, despite the fact what your employer says, I would make sure that you check with us as well, just to keep yourself right, because there's certain timescales, etc. If you are, you know, want to take it up with an industrial tribunal, you really there's timescales within that as well. So you don't want to be too late to do that or not have the evidence that perhaps you need. If you're in this situation, considering any of the above, contact us, as I've said before. There's eligibility criteria and qualifying periods for taking on unfair dismissal claim to an employment tribunal. Okay, so changes to your shift. This can happen. It's quite commonly happen. If your employer wants to change your shift pattern, we have a guide on changes to shifts and to check your legal rights. So I'd advise you do that, because that does happen. As quite commonly happens. Your contract of employment or local policy, they might allow changes to your shift pattern, provided your employer follows the correct process, and that's something you need to be aware of as well. Policies and procedures, processes, protocols, that should be part of your induction, but also you should feel free and able to readily access these documents as well throughout your term of employment. If you have the legal right to continue working for your existing shift patterns, firstly discuss this with your employer, but contact us if that issue can't be resolved. If you want to change your hours or pattern of work, read our flexible working advice guide, and that's certainly become a huge focus over recent years, and particularly to retain the nursing workforce, to ensure that there's flexible working options for people as well, because people have family, they have other reasons for requesting flexible working, and it's something that we are trying to promote, and quite often it can actually work very well for the employer, because it means that rather than you leaving and going elsewhere for another job with those different terms and conditions, you'll stay with them and they'll retain you. So handing in your notice, if you want to leave your job, you'll have to give notice of resignation to your employer. How much notice, as Claire mentioned earlier on, that will depend on your contract or written particulars, and you can find out more about that from our notice advice guides. But also, there could be a written term within your contract that is 4 weeks notice, but your employer actually might say, I don't need you to work that, or I'll pay you in lieu of that. There's lots of arrangements that can go on with that. So just take advice from us if you feel you need it. Layoffs can happen when there is insufficient work for employees and they're asked to stay at home. That tends not to happen very much in our sector just now, but it still is a possibility that it could happen. Short-time working is where an employee's hours of work are reduced. So unless your contract states otherwise, your employer is legally bound to pay you for your contracted hours and should not be telling you that you have to pay time back at a later date. But we also have, as you probably have heard, 0 hours contracts as well. So that would be obviously separate advice for that. Your employer could make a claim for damages against you if they suffer measurable financial loss due to your breaching the contract. They can do this either by initiating a claim against you or by counter-claiming in an employment tribunal. In practice, this is rare, but this is why it's so important you keep yourself right. You contact us if you've got any concerns at all, record, information, conversations, make sure when you're speaking to employers, there's maybe you have a witness there or the information's been recorded. It keeps yourself right for the future. So the slide there is just all the different ways that you can contact RCN direct to get advice. As you say, there's a lot there. You will be entitled to copies of the slides. This can be used for your revalidation, and I'll pass you on to my colleague Leanne next.
My name is Leanne Mojo. I'm one of the employment lawyers and legal officers from the South West Employment Team, and I should be talking to you broadly speaking about repayment clauses and unlawful deductions from wages. Particularly, this happens in not just private independent sector contracts, but also happens in the NHS as well. But I will focus today on the private aspect of it, the independent sector. If you could have the next slide, please. Thank you. So this has come to my attention and largely through legal surgeries and legal referrals, because we are getting a lot more people affected by the recovery of sometimes very, very high, steep charges. The RCN is committed to providing support to internationally recruited workers, because we feel that they should be afforded the same working conditions as all care staff and treated with the same dignity and respect, and not exploited because of the fact they came from the overseas workforce. And what you will find with contracts such as this is that one of the problems in helping our members is that right at the beginning of their employment, they're often required to sign contracts with onerous clauses. And then upon leaving this contract or this employment, they discover that they have signed to agree to various vast deductions from their pay. And it's worth having a look at the articles. I'm not sure actually if the links here will work, but the articles I refer to are really, they call it shocking abuse, and it talks about the conditions, and in extreme cases that one nurse was required to pay fees as steep as £14,000. They wanted to change their job or return home early. In other conditions, they can be required to be permanently on call, working long, up to 19-hour shifts without breaks, having their wages withheld, being required to pay large sums to recruitment agencies. And I see anecdotally conditions where our members are forced to leave their contract, for example, because they are promised a certain number of hours per week, for example, and they're just not getting the work, and they're put in very compromising positions. And then to be faced with having these extortionate repayment clauses is really, really unfair. So unlawful deductions from wages. So deductions from wages are, typically speaking, unlawful. However, they are authorised by statute, or if they are agreed with contractually with the employee. So to satisfy the Employment Rights Act, there has to be a document. This document must clearly state that the deduction can be made from the employee's wages, and that the employee has agreed to it. I've referenced a case on there. And it must be clear. It must be clear as to what the deduction relates to. Blanket clauses, and we'll come on to that in a moment, will typically not be enforceable. Time frame wise, it's important to act quickly, because if you are to recover any fees deducted, you must do so within 3 months of the last deduction. So it can be cumulative, but you must act within 3 months of the final deduction. And it falls from the date that the payment was due. So I ask you, are these deductions clauses lawful? They are, but only in certain circumstances. So there will normally be either worked into the contract, or more helpfully a separate document which sets out specifically what it is that the employer is seeking to recover, but they will not be lawful or lawfully deducted if they amount to a penalty clause. So the deductions clause in that respect will only be valid if it is a liquidated damages clause, and that basically means that it has to represent the loss, the reasonable loss that the employer has suffered. So a clause, a penalty clause designed to punish the employee for leaving the contract, will not be enforceable. It has to be what's called liquidated damages, and this reflects a genuine pre-estimate of the employer's loss. So I'll come on to a typical clause in a moment, but you might find a simple clause to the effect of, if you leave within 2 years, we will recover the sum of £3,000 from you. But that doesn't represent anything. That is designed with the intention to restrict, it's a restraint of trade effectively, to restrict the movement of the worker and to punish them for moving on. And that isn't the purpose of a lawful deductions clause. I've put at the bottom of the slide here actually that it's advisable to keep a record of expenses, which evidence the payments that have been made by the employee, because we have seen certain circumstances where the employer has sought to deduct fees and expenses which would otherwise in theory be lawful, but they haven't actually incurred. So if the employee has made payments for certain training or flights or any other expenses themselves, to keep that record, because it's really important that you can evidence it when it comes, or if it should come to a dispute. Okay, so these are the stages that we would go through in looking at whether or not the deduction can be made. So the first question is the sum legally due? And if so, what is the sum? This goes back to the point I'm making about a quantifiable sum rather than a figure representing some penalty. Has there been a deduction from the sum due? And that deduction occurs where there is a shortfall in the amount of wages when compared to the amount properly payable, so says the Employment Rights Act. And was such deduction authorised by the Act, the term of the contract, or an agreement between the parties to which they have consented to in writing prior to applying the deduction? It might be that actually there hasn't been a deduction made. So more recently, I've had a situation whereby the deduction hasn't been made, but it's been sought to be recovered as a debt in the county court. And that's something that we can also support our members in defending and advising upon. So you might find that is another scenario which arises. Okay, so I've given some examples here of repayment clauses, the sort of contracts clause that you might see within the contract. So if I look at the first one, if on termination of employment you owe the company money as a result of any loan, overpayment, default on your part for any reason whatsoever, the company should be entitled as a result to basically deduct from the final salary. Now that is the mechanism by which they will justify the deduction. But if we go down to the bottom, should you terminate your contract for any reason within 36 months of the start date, the following penalties apply. The administration cost of £2,500. Actually, can I have the next slide, please? And I'll come on to that altogether. So in determining this, we have to look at whether this amount deducted, so there's this global figure, does this represent this genuine pre-estimate of loss? So simply because it is a figure that's been been described as admin cost, it would seem disproportionate to the amount actually recovered. So that in those circumstances, the purpose of the clause is again to deter the employee from leaving the employment. And then we would need to look at that as against, was this a proportionate aim, i.e. did the employer have a legitimate interest at the time the contract was entered into? Because it's not the case that any sum sought to be recovered is unlawful. It's simply the case that it has to be proportionate, and in many cases it isn't simply. So again, we said not just are the costs quantifiable in considering when the sums are due, but actually did the training, for example, actually happen? Because I have had, again anecdotally, more than, well, several occasions where what is being recovered or what is being claimed has not actually been incurred by the employer. So again, going back to the point about keeping records, it's also advisable to keep a note of training, because the employer will have to evidence the cost that they're looking to recover, and if the training hasn't taken place, they simply won't be able to. Again, with admin fees, the employer will bear the burden of showing that the fee was proportionate and that it had a legitimate purpose in so doing. I'll just gloss over the ISC, the skills charge, because I'll come on to that in a moment. But it does have, the organisation will pay an immigration skills charge, but won't be able to recover that, although sometimes does look to. So the Department of Health and Social Care have a code of practice, and actually it's been brought to my attention quite recently that the NHS have also gone one step further and have put together a code for repayment clauses for international nurses. The NHS code it's more helpful because it sets an amount of up to £3,000 with a sliding scale, but of course in reality the majority of cases that I see don't fall within the NHS, they do fall within the independent sector, but it's worth noting because it sets the appetite a tribunal might have in determining whether costs are able to be recovered or not. So the code will apply to all. It's best practice. I say it's not legislation, sadly, but it goes some way into, again, determining what is likely to be recoverable. So it does very clearly say in the code that the following I've listed here by bullet point: the agency fee, the skill charge, the sponsorship license fee, the cost of the interview process, and interest are not recoverable. So very often you will see costs of the interview, costs of recruitment recoverable, or the employer looks to recover them upon departure. But it's very clear that the expectation is that they would not do such a thing. And the code also states that there should be a fair repayment method. So it shouldn't be simply removed all from one final salary. There should be a monthly plan or some other fair agreement by which any legitimate cost can be recovered. So the new NHS guidance does talk about a sliding scale, but the code also said that a repayment schedule, as well as the repayment schedule, it must taper downwards because there's already been some benefit the longer the employee remains in employment. And this isn't necessarily the only combination, but this is I suppose an example of what is best practice. So the varying deductions depend on how long the employee has worked there, and then no payable expenses after 36 months of service. And again, that is the new guidance in the NHS, 36 months of service. So it is a good guide, and it's worth referring to, as even though it's not, it is guidance. It will help in looking at what is and isn't recoverable. So the RCN's policy regarding membership of international nurses, as I mentioned before, it's difficult because very often the contracts have already been signed prior to to workers coming to the UK. But the RCN do offer a slightly different process of membership. So under this policy, normally in previous policy, regional support can't be provided where the member joins the RCN after the event. But we're mindful that actually people don't always have access to RCN advice So under this policy, we will provide support, legal support and regional support and advice, even when a member joins after the incident and then contacts the RCN. I'm just whizzing through this because I'm conscious of time. So the immigration skills charge, it cannot be passed on to the employee. So if the UK Visa Immigration discover that it has been passed to the worker, it can revoke the employer's sponsor license. So it's an absolute no-no. But I will leave that to Sophia, who I'll just hand over to.
My name is Sophia Barrett-Melangeni. I'm a senior immigration advisor and solicitor in the Immigration Advice Service. So what I will be covering this evening is what duties are owed to the employer when a sponsored worker leaves employment, what duties that the worker must undertake when they leave. I'll also cover some aspects of the immigration skills charge and the issue about curtailing existing leave to remain. So what an employer must do once a date is known as to the last date of the employee's employment with them, and this goes for if they resign or if they're dismissed or if there's a redundancy, is that the sponsor has to notify the Home Office of that date. So that places a sort of trigger really for the Home Office. The Home Office knows, okay, something's afoot. This worker is in the process of leaving this employer. And the sponsor must do that within 10 days after the worker's left employment. So once the worker has left, you simply can't start working for a new sponsor. If you're offered a start date of a new sponsor, there is a process that has to be followed. What we have found in my team is we've had some members who've contacted us. They've left employer A, they've gone to work for employer B and have not notified the Home Office of that relevant change. Often the new employer has said, oh, you don't need to submit a new application to the Home Office. That's not correct. And if a worker does start working for a new sponsor without having applied to the Home Office, they're effectively working in breach of the immigration rules, and the employer is also employing somebody who does not really have that right to work in that instance. So once an employer has left one sponsor, they have to obtain a new certificate of sponsorship with their new employer. Once they receive that certificate of sponsorship, they have to go online. It's an online application system, not a paper application system. They have to go online and submit their application to update their health and care visa with details of the new sponsor. You cannot actually submit an application without the COS. The COS contains a specific reference number that you have to input into the application. You can continue working in your current job whilst your new application is being considered, or to work out your notice period. So if you, as you've heard in previous slides, you will have to give a notice period and work through that notice period. And if you have submitted your application to extend your visa, whilst that's under consideration, you can just continue working through your notice period. You cannot start working for a new employer until you've received a successful decision from the Home Office. So you've received your decision, you're still working your notice period, that's absolutely fine. At the end of that notice period, you can then begin working for your new employer. That last point number 4, during lockdown, that stipulation, there was a special, well, they didn't the government didn't change the rules. They just allowed a sort of special dispensation that people could start working for a new employer straight away. They didn't have to wait for a decision about their application. That ended in October last year. So you now revert back to the previous position of not being allowed to work for the new employer whilst your application is still under consideration. So the immigration skills charge, not the same as the immigration health surcharge. There's often confusion between the two. As of August 2020, when the health and care visa replaced Tier 2 General migrant visa, there is no immigration health surcharge payable under the terms of the health and care visa. And as already stated, the fee is payable by the employer only. The employer mustn't pass this fee on to the worker, but as we've already heard by from my colleague Leanne, some employers will try to sneak that in by calling it an administrative or recruitment charge or something like that. Some employers will try to recoup that fee back. It's worth noting that there are refunds available to employers for the immigration skills surcharge. The immigration skills surcharge if the employer doesn't take up employment, for example. So there are specific certain circumstances where the employer doesn't lose out on the money that they have actually already paid for the immigration skills charge. So curtailment of leave to remain. So this often comes up, and I think there might be some confusion about this. So once you've ceased working for your sponsor, and as we said, you must extend to leave your leave to remain as a skilled worker, or if you're not able to do that, you need to switch into another visa category. You can't just stop work and just do nothing about your immigration status. So the decision has to be made. Do you want to remain on the health and care visa route, or if you want to remain in the UK, you need to, and you don't want to remain on the health and care visa route, you do need to switch into a different category before your visa expires. Now, if you once you have left your employer, as I mentioned in an earlier slide, the employer has notified or will have notified the Home Office of your last date of employment. So the Home Office have been put on notice that you no longer continue to work for that employer. So the Home Office are looking to see, well, what are you going to do next? Are you going to switch into a different category? Or are you going to update your visa with a new employer? So they are looking out. Now, there isn't any sort of time scale as to when the Home Office will expect you to find a new sponsor. The advice is essentially you start looking for a new job as soon as possible, and that's particularly in the situation where there's been a dismissal. So the 60 days deadline, it doesn't start, so the clock doesn't start ticking at the point at which you've left employment. It actually starts from the date that you are notified in the letter and by email that your leave has been curtailed or shortened. Curtailment effectively means shortened. If you have more than 60 days left on your visa, that's just simply going to be cut short to the 60 days period. Now, it's important that you notify the Home Office of any changes in your contact information, because they'll simply send the letter or email to their last known email address and postal address. It's not an excuse to state that, well, I never received it, so therefore I'm not liable. The Home Office will do something called saving letter to file. So if they've tried on several occasions and they've not managed to get hold hold of you. That whenever they send a letter, that it's always sent by recorded delivery. The Home Office, because they've lost a few cases in the past with regards to curtailment letters, that they've wisened up now. They send postal letters by recorded delivery. If nobody signs for that and it's returned, the letter is returned to the Home Office, it simply gets saved on the immigration file and it's deemed as served. You've been told. You may not have signed for it, you may not have received it, but as far as they're concerned, you got it, even if you hadn't. So it's really, really important to update the Home Office of changes of contact, so you're kept abreast of as to what your situation is. And that's the end of my my presentation. Thank you very much.
Thank you, Sophia. And just to introduce myself to those who've come in since we've started, my name is Lucy Michina. I'm the Regional Director for the Southwest, and I'm just going to go through this one slide, and then we will have the opportunity to respond to your questions. So many thanks to those of you who are already posting your questions using the Q&A function. Please remember that there is no silly question. You know, just ask, absolutely, and we're here to respond to that. So some of this has been covered by colleagues, but I'm just going to start off with the professional development, which is one of the functions, one of the services that we provide. Our CPD courses with academic credits are developed by the Royal College of Nursing, and they're accredited by the Coventry University. And that portfolio of courses various. That could include infection prevention and control, leading the way, improving mental and physical health, among others, and this is available for members as well as our non-members. So there is a link there that can take you to the page for the professional development. So please do take a note of that. The other reason as to why we ask that you would join the Royal College of Nursing, if you haven't already done that, is the workplace support. And perhaps this is what we're known a lot more for, and absolutely what we do day in, day out. So we're here to provide you with that specialist workplace support and guidance. Again, if you're not a member of the Royal College of Nursing, there's a link there that can take you directly to RCN Direct, and you can sign up to become a member. I wouldn't want to leave it till later, absolutely, given the kind of work that we do in those clinical settings. Leanne has gone into depth around the legal advice. Again, that is a comprehensive support and information from the largest in-house legal team of any UK trade union. So again, we're here to support, and that of course will tie in with the workplace support or not sometimes, but it is there for you when you're a member of the Royal College of Nursing. Member support services, again, it was very useful when I attended one of the sessions, and I heard some of the feedback that we were getting from colleagues that have had the opportunity to ring the RCND. So immigration advice, welfare advice, again, supporting with the financial well-being or even questions around that, career coaching and CV writing, interviews preparation for that, planning for your career, telephone counselling services as well. We do a lot of that, peer support for members with disabilities, and of course, there's a handy guide to common expressions, English expressions. So again, you can find all that information on the link that's provided there. Lastly, but not least, and of course this is not an exhaustive list, is the careers advice. So do visit our extensive nursing careers resource for helpful guidance on career planning. So I'm just going to pause there, but again, like I said, it's not exhaustive. We do have a link. There's a web page that's been set aside for our internationally educated nursing staff. Do visit that link there, that page. There is plenty of information around various things that you can do, including forums that you can join in as well. And I'm sure we're going to be posting that as well. Just take note of that. So many thanks. And I am going to now hand over to our moderator, Tony.
Thank you, Lucy. We've got a couple of questions. I think the first one, Leanne, if you wouldn't mind answering for this question, it's if the cost of recruitment is not stated in the contract of employment, what can an international nurse do if he or she decides to leave the employer when it comes to repayment?
So it's important to realise that actually there's no automatic entitlement to recover costs of recruitment. So broadly speaking, and the starting point must be if there is nothing within the contract that reserves the right on the employer's part to recover any costs, then they shouldn't be recovering any, full stop. So I think if I've understood your question correctly, if you've got to a point where you leave employment and the employer seeks to recover something it hasn't reserved the right to, then we will be saying that that's an unlawful deduction from wages if it's deducted. And of course, if it's recovered by another means, then we would be defending that.
While we've been speaking, we've had another couple of questions come in, and the first one, again, it may be for you, Leanne, sorry. It's yeah, I'm on maternity leave at the moment. If I change my sponsorship now, do I need to repay my maternity pay to them 6 months now?
Well, from a contractual point of view, it would depend if the maternity leave is an enhanced contractual rate, in which case there is typically a provision in there which does provide for leaving within a certain amount of time following your return. Now, in terms of any other maternity pay, Sophia, you might have a better idea than I would on a non-contractual or any other entitlement.
Well, maternity allowance is one of the few public funds that health and care visa holders can actually claim. So if they're eligible, that is a public fund effectively, so that wouldn't be something that you would pay back because that's not a contractual benefit as such. So if you're on maternity allowance, that's not something that you would pay back at all.
So it would depend upon to answer the question as best we can, it would depend upon.
It just depends. It just depends on what's the source. Is it statutory maternity pay? Is it maternity allowance? That's a non-contributory benefit. And if
it's contractual, we just need to look at the provisions in the contract to see what they were.
Hi, I just got promoted to a higher role still within my company, but I will need to transfer to another of the company's branches. Do I need to inform the Home Office as it is an internal transfer, but the initial role has changed to another higher role?
No, I mean, if it's the same sponsor, but you're doing a sort of another job, I mean, that's a relevant change in that whoever's in charge of HR needs to notify the Home Office and advise that there has been a change, because there'll be a salary change. So do you still meet the minimum salary for a health and care visa? So that needs to be updated, and also the code. So for instance, if you're a nurse, there's a specific code that will be listed on your current certificate of sponsorship, will be 2231, which is for nurse. If you're still working as a nurse, but let's say it's a sort of less of a clinical role, it might be more of an educational role, you do a lectureship, for example, that there is a code for that. So it's just a matter of updating your existing COS as opposed to another application with a fee that you have to pay. So it just depends on what you're doing and how much you're being paid.
Okay, what constitutes public funds for someone on health and care visa?
Oh, okay. I'm going to put a link, if you bear with me, but I'll tell you, it's a very short list, so it will take me literally 10 seconds. So contribution, job seekers allowance, guardians allowance, incapacity benefits, contribution-based employment and support allowance, maternity allowance, retirement pension, statutory maternity pay, statutory sickness pay, and widow's benefit and bereavement benefit. That's it. I'll put a link. But it's a very, very short list. Basically, there's not much you are eligible for.
So now I'll just hand over to Lucy.
Yeah, many thanks, Tony, and thank you, everybody. These marks are end of this session today. And just to remind everybody that we are running these sessions monthly across the UK. We're going to be having another session in about 2 weeks' time, so do keep an eye on the page for international nurses. And as I mentioned at the beginning, you can use the information that you've learned today for your revalidation. So however, we would love to hear your feedback. So we're going to post a link there where you can just take a few minutes and give us some feedback. We would love to continue to engage with you. So your feedback absolutely very helpful for us to be able to do this. And once again, I just want to say thank you for joining us today, and hopefully to see you again in about 2 weeks' time. Thank you.